reserve my decision, and then can you come back next week? Any date that is convenient for you?
Suggested it twice. Can you come back on the 9th?
9th, Tuesday.
Then Tuesdays.
That based on the information that was given by the board, we granted a claim mention. Within a reasonable time, the court grants deems reasonable to conclude the investigations. That's it.
You know, first I'll start by the last statement made by my colleague. Those statements are not made under oath. He has not sworn himself in, number one. Number two, when the accused person was brought before this one was on the 1st of September. Yes. No, I did not say about doing that. What I said is that I needed proceedings. I did not say No, I have not gone there. Yes, Your Honor, as I said earlier, those statements are not qualified as affirmance made under oath, as the Constitution says. But number two, the accused person, Your Honor, rather the suspect, was brought before this honorable court on the 1st of September 2025. The investigating officer standing before you made an application for the accused person to be detained pending investigations. And through the application on that particular day, they sought for 21 days. Those 21 days, Your Honor, in their estimation, and looking at the nature of the case, they thought that those were sufficient to make a decision as to whether to recommend to the ODPP for charging the suspect. After the 21 days, Your Honor, you were gracious enough and granted them 30 days, additional 9 days. When we came back before you, the investigator mysteriously disappeared, did not show up. And Suomoto, you extended 2 weeks for him to come back with a report. And from the record, you will see that it was a final extension. Thereafter, the investigating officer showed up again, requested for 4 weeks. Your Honor gave them 5 weeks, very graciously, just like the other times. And in fact, you gave them actually 6 weeks, not even 5 weeks, 6 weeks. When 6 weeks ended a long time ago, the 22nd of November. That's when the 6 weeks ended. We've been in court with a miscellaneous application for more than 90 days. Extension of those orders are anchored in law. They're not out of the blue. Under Section 36A, particularly 36A 7. Sorry, let me just get the correct section. In that particular section, that is, extension can only be done for not more than 90 days. In fact, that is the 36A 9. But we are more than 90 days, yet the investigating officer is telling you that they need more time. Then I was prepared for that kind of an application, and there was a recent decision by the High Court in Tika. This is Honorable Judge Muchemi. That is on the 10th day of September 2025.
Yes.
But on paragraph 54, which I will share with you, paragraph 54, my Lord, Your Honor, the Lord Justice says this: as a general rule, an arrest of a suspect should not be made unless and until his or her case has been investigated with sufficient evidence requiring an answer on the complaint. Your Honor, what the investigating officer wants you to do is to reverse it. That let us charge and then investigate. But that paragraph is not an obiter. It's a ratio decidendi. But if you assist them to do that, you will be falling on the traps of paragraph 55. You will be encouraging false arrests. That's what the court is saying at paragraph 55. Your Honor, that notwithstanding, such kind of applications must be made under section 36 by way of an affidavit that is sworn by the investigating officer, supported by way of an application supported by an affidavit. But although there are stories, we are being given stories by the investigating officer, we are doing this, we are doing that, we are doing, but they had sufficient time. You're not in the same decision at paragraph 57. The Honorable Judge is quoting another decision by Mumigo J, who is now a court of appeal judge, reprimanding the conduct of police officers, saying that the conduct by law enforcement officers profiling suspects on mere suspicion, arresting and detaining them with no evidence of crime committed is arbitrary and discriminatory guaranteed in our Constitution. Your Honor, that invitation to continue profiling the suspect should be graciously denied, declined by this Honorable Court. Your Honor, what the investigating officer does not seem to know that he's doing is that he's violating the rights of the people. And which right, they may ask? The right against psychological torture. It's not only a question of you are out on bail, we can take as much time as we want. You know, the suspect is out on bail, granted. But he may not be well psychologically because he does not know what is hanging on his head. So that under the provisions of Article 50, torture is a non-derogable right. Article 25. It cannot be limited by anyone, including this Honorable Court. Aside from that, Your Honor, they have his travel documents. The freedom of movement is not only limited within the country, it can be outside the country as well. But the prosecution is telling you let us hold on to his passport so that the works that probably is supposed to do outside the country, he can wait for us to do whatever it is that we want to do here. That's another right that is being limited. And I will plead with you, because it looks like investigations are yet going on. They're yet to investigate. That is within their power under the National Police Services Act, particularly under Section 52 of the National Police Services Act. We don't have to keep the suspect in court. They say that the government has long hands. That is, I paraphrase. So that they can summon him under their powers, under the standing orders, police service standing orders, under the National Police Services Act, but we don't have to keep him in court and violating his fundamental rights. For those reasons, we strongly object to any further extension, the court having granted several extensions. And that the file can be closed. The court will then defunct us, and then now they can now decide what to do with the information they have. That is all from me.
All right, thank you.